Canon 6, Accountability, Part 3, Sections 36 to 53 of the Code of Professional Responsibility and Accountability. Section 36, Assisting in the commission of an offense. Any lawyer who shall knowingly assist another lawyer in the commission of any serious, less serious, or light offense punished by the CPRA may also be held liable. Section 37, Sanctions. A. If the respondent is found guilty of a serious offense, any of the following sanctions or a combination thereof shall be imposed. First, disbarment. Second, suspension from the practice of law for a period exceeding 6 months. Third, revocation of notarial commission and disqualification as notary public for not less than 2 years. Or fourth, a fine exceeding 100,000 pesos. B. If the respondent is found guilty of a less serious offense, any of the following sanctions or a combination thereof shall be imposed. First, suspension from the practice of law for a period within the range of 1 month to 6 months, or revocation of notarial commission and disqualification as notary public for less than 2 years. Second, a fine within the range of 35,000 pesos to 100,000 pesos. C. If the respondent is found guilty of a light offense, any of the following sanctions shall be imposed. First, a fine within the range of 1,000 pesos to 35,000 pesos. Second, censure. Or third, reprimand. In addition to the above sanctions in paragraph C, the respondent may also be required to do community service or service in the IBP legal aid program. In all instances, when the offense involves money or property owed, which is intrinsically linked to the lawyer-client relationship, the respondent shall be ordered to return the same. Section 38, Modifying Circumstances. In determining the appropriate penalty to be imposed, the court may, in its discretion, appreciate the following mitigating and aggravating circumstances. A. Mitigating circumstances. First offense, except in charges of gross misconduct, bribery or corruption, grossly immoral conduct, misappropriating a client's funds or properties, sexual abuse, and sale, distribution, possession, and or use of illegal drugs or substances. Second, absence of bad faith or malice. Third, return of the amount owed. Fourth, expression of remorse. Fifth, reconciliation with the complainant. 6, rectification of wrongdoing. 7, act or omission did not prejudice the client. 8, age. 9, number of years in the practice of law. 10, humanitarian considerations. And 11, other analogous circumstances. B, aggravating circumstances. First, finding of previous administrative liability where a penalty is imposed regardless of nature or gravity. Second, age. Third, number of years in the practice of law. Fourth, employment of fraudulent means to conceal the offense. Fifth, respondent's act or omission was tainted with bad faith or malice, except when it is an element of the offense. 6, lack of remorse. 7, failure to comply with the orders of the court and the IBP in relation to an administrative case. 8, other analogous circumstances. Section 39, manner of imposition. If one or more aggravating circumstances and no mitigating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period or amount not exceeding double of the maximum prescribed under this rule. The Supreme Court may, in its discretion, impose the penalty of disbarment depending on the number and gravity of the aggravating circumstances. If one or more mitigating circumstances and no aggravating circumstances are present, the Supreme Court may impose the penalties of suspension or fine for a period or amount not less than half of the minimum prescribed under the CPRA. If there are both aggravating and mitigating circumstances present, the Supreme Court may offset each other. Section 40, penalty for multiple offenses. If the respondent is found liable for more than one offense arising from separate acts or omissions in a single administrative proceeding, the court shall impose separate penalties for each offense. Should the aggregate of the imposed penalties exceed 5 years of suspension from the practice of law or 1 million in fines, the respondent may, in the discretion of the Supreme Court, be meted with the penalty of disbarment. If a single act or omission gives rise to more than one offense, the respondent shall still be found liable for all such offenses, but shall nonetheless only be meted with the appropriate penalty for the most serious offense. Section 41, fair and reasonable fees. A lawyer shall charge only fair and reasonable fees. Attorney's fees shall be deemed fair and reasonable if determined based on the following factors. A, the time spent and the extent of the service rendered or required. B, the novelty and difficulty of the issues involved. C, the skill or expertise of the lawyer, including the level of study and experience required for the engagement. D, the probability of losing other engagements as a result of acceptance of the case. E, the customary charges for similar services and the recommended schedule of fees, which the IBP chapter shall provide. F, the quantitative or qualitative value of the client's interest in the engagement or the benefits resulting to the client from the service. G, the contingency or certainty of compensation. H, the character of the engagement, whether limited, seasonal, or otherwise. And I, other analogous factors. Section 42, division of fees upon referral. A lawyer shall, in case of referral of legal services in favor of another lawyer, with the written informed consent of the client, be entitled to a division of fees in proportion to the work performed and responsibility assumed. Where a lawyer undertakes to complete unfinished legal business of a deceased lawyer, a division or sharing of fees is allowed with the deceased lawyer's legal heirs or estate. Section 43, non-sharing of fees with non-lawyers. A lawyer shall not share, split, or divide, or stipulate to divide, directly or indirectly, a fee for legal services with persons or organizations not licensed or authorized to practice law. Section 44, confidentiality. Proceedings against lawyers shall be confidential. However, the final order of the Supreme Court shall be published like its decisions in other cases. Section 45, sworn statement after service of suspension. Upon the expiration of the period of suspension from the practice of law, the lawyer shall file a sworn statement with the Supreme Court through the office of the bar confidant to show that the petitioner during the period of suspension, A, has not appeared before any court, tribunal, or other government agency, whether in respect of current, former, or prospective clients. B, has not signed or filed any pleading or other court submission. C, has duly informed his or her clients, law firm, law school where the lawyer is teaching, legal clinic, or other legal service organization of which he or she is a member regarding the suspension. And D, has not otherwise performed any act directly or indirectly that amounts to the practice of law. The sworn statement shall state the date of the lawyer's receipt of the order, decision, or resolution imposing the penalty of suspension, as well as a list of the lawyer's engagements affected by the suspension, indicating the relevant court, tribunal, or other government agency, if any. Copies of the sworn statement shall be furnished to the local chapter of the IBP, to the executive judge of the courts where the suspended lawyer has pending cases handled by him or her, or where he or she has appeared as a counsel. Section 46, Resumption of Practice of Law. The sworn statement shall be considered as proof of the suspended lawyer's compliance with the order of suspension. Such lawyer shall be allowed to resume the practice of law upon filing of the sworn statement before the Supreme Court. However, any false statement in the sworn statement shall be a ground for a complaint for disbarment. Within 5 days from the filing of the sworn statement and the office of the bar confidant determines that there is a false statement stated therein, it shall refer the same to the court for its immediate action. Section 47, Reinstatement in the role of attorneys. A lawyer who has been disbarred may file a verified petition for judicial clemency after 5 years from the receipt of the order, decision, resolution of disbarment. Section 48, Petition for Judicial Clemency. The verified petition for judicial clemency shall allege the following. A, that the verified petition was filed after 5 years from the receipt of the order, decision, or resolution of disbarment. B, that the disbarred lawyer has fully complied with the terms and conditions of all prior disciplinary orders, including orders for restitution. C, that he or she recognizes the wrongfulness and seriousness of the misconduct for which he or she was disbarred by showing positive acts evidencing reformation. D, that he or she has reconciled or attempted in good faith to reconcile with the wrong private offended party in the disbarment case, or if the same is not possible, an explanation as to why such attempt at reconciliation could not be made. Where there is no private offended party, the plea for clemency must contain a public apology. And E, notwithstanding the conduct for which the disbarred lawyer was disciplined, he or she has the requisite good moral character and competence. Any of the following allegations may also be made in support of the petition. A, that he or she still has productive years that can be put to good use if given a chance. Or B, there is a showing of promise, such as intellectual aptitude, learning or legal acumen, or contribution to legal scholarship and the development of the legal system or administrative and other relevant skills, as well as potential for public service. Section 49, Action on the Petition for Judicial Clemency, prima facie merit. Upon receipt of the petition, the Supreme Court shall conduct a preliminary evaluation and determine if the same has prima facie merit based on the criteria. If the petition has prima facie merit, the Supreme Court shall refer the petition to the office of the bar confidant or any fact-finding body the court so designates for investigation, report, and recommendation. If the petition fails to show any prima facie merit, it shall be denied outright. Section 50, Investigation by the office of the bar confidant or other fact-finding body. The office of the bar confidant or any other fact-finding body designated shall conduct and terminate the investigation and submit to the Supreme Court its report and recommendation within 90 calendar days from receipt of the referral. Section 51, Decision on the Petition for Judicial Clemency, Quantum of Evidence. The Supreme Court shall decide the petition on the basis of clear and convincing evidence. Section 52, Prohibition against employment of disbarred or suspended lawyer. A lawyer who has been disbarred or suspended shall not be employed or engaged in the practice of law, including the performance of the following acts. A, providing legal consultation or advice. B, appearing on behalf of a client in any hearing or proceeding before any court, tribunal, or other government agency or office. C, appearing as a representative of a client at a deposition or other discovery matter. D, negotiating or transacting any legal matter for or on behalf of a client with third parties. Or E, receiving, disbursing, or otherwise handling a client's funds. Or F, teaching law subjects in any educational institution. G, acting and being commissioned as notary public. A suspended lawyer shall immediately cease and desist from the practice of law until the suspension is lifted by the Supreme Court. Any client previously represented by a suspended lawyer may engage the services of a new lawyer. The disbarment or suspension of a handling lawyer shall not terminate the lawyer-client engagement between the client and the law firm unless the client chooses otherwise. Section 53, costs. All reasonable and necessary expenses incurred in relation to disciplinary and disbarment proceedings are lawful charges for which the parties may be taxed as cost subject to proof. That's it. Canon 6, Accountability, Part 3, Sections 36 to 53 of the Code of Professional Responsibility and Accountability.